This is Paul Schneiderman today on the 64th edition of Sports and Stuff on RainierAvenueRadio.world. Today I have two very special guests, two old friends, Seattle area attorneys Mark Lamb and Aaron Wolff. We're going to have a show today about just some fun sports law topics. Well, they may not all be that fun, but they're interesting topics. So I can't think of two better guys to have on this. Before I go further with this discussion with Aaron Wolff and Mark Lamb, I want to recognize my engineer today, James Gerd. James does a lot at the Rainier Avenue Radio. He also is the host of the After Dark show here. He's sort of a multi-purpose utility guy here. James does good work. A lot of good things going on at RainierAvenueRadio.world. We have a sports department with multiple shows hosted by Rick Dupree, Granville Emerson, Ronald Laurent host a show. Mazvita Marari hosts the Seattle Sports Weekly show. Pat McCarthy, Mazvita co-host a show. Mark Bryant has a good fitness-based show. Juan Cotto has a show. We have entertainment shows. We have political shows, lifestyle shows. So definitely go to RainierAvenueRadio.world. My show, Sports and Stuff, has been going on now for a little over 2.5 years. You can listen to all my interviews on Mixcloud and my website, plslawoffices.com. Well, both of you, as I mentioned earlier, have been friends for many, many years. Both are dads raising kids. They both have some perspectives on sports and sports law issues. Mark Lamb is a Duke University and UCLA law grad, Seattle native. Mark now lives and works in Bothell, Washington. He served in the Bothell City Council for many years. Aaron Wolff is a Mercer Island native. Aaron practices in predominantly criminal defense. He's worked on some civil litigation issues. Mark, as an attorney, has worked primarily in election law, civil litigation, and Mark's handled a few criminal cases over the years as well.
Just a handful.
A handful. Aaron is a graduate of Emory University and Seattle U Law School, my alma mater. Aaron worked as a criminal prosecutor for many years, and like I mentioned a minute ago, he's been a criminal defense lawyer for many years. Both these gentlemen, I want to mention, were involved in the I-93 Deal is a Deal initiative back in 2007, which was an effort to try to lock the city of Seattle in to enforce the Sonics lease through 2010. Well, we'll talk about I-93 for a minute or two, but gentlemen, thank you for coming on Sports and Stuff on Rainier Avenue Radio.
Thanks for having us, Paul.
Yeah, thanks for having us, Paul. It's great to be with you and great to be with Aaron.
Absolutely. Fun little Thanksgiving Eve discussion here. We'll record it. It'll be announced next week. So in about 2007, during the Sonics relocation battle, Aaron Wolff over here came up with the idea to prevent the city of Seattle from accepting an early buyout of the Sonics lease, and Mark ended up writing the initiative I-93. It was dubbed A Deal is a Deal. Little history is after the initiative was filed, the city of Seattle, the council agreed to, through a resolution stating they would enforce the lease and they didn't want the Sonics to leave before 2010. We know the history. That ended up not happening. But I got a question for both of you. And if that initiative went forward and if it passed, I'll let Mark or Aaron go first, whichever one of you wants to go first. Do you guys think that could have resulted in a different outcome of the Sonics relocation? You want to go first, Mark?
Sure. I mean, I think there's a real possibility that it could have. And I think that the lease was the one kind of hammer that the city had to keep the Sonics in Seattle. And I think that if they had stuck to a specific performance and if that had gone into effect, I think there is a real chance that they would have been able to enforce that and to keep the lease in place. I think that was really the one ability that the city of Seattle had. As you know, it ultimately went a different direction, had a negotiated settlement whereby they said, well, the legislature has a certain amount of time to do this. That did not end up retaining the Sonics. And so I think in some ways there were a lot of people who were counseling compromise, including a lot of people on the Seattle City Council, because they felt like that was the better part of wisdom at the time, to not antagonize the new owners and to try to give them a field to run with to secure the team. But I think, with the benefit of 2020 hindsight, the outcome certainly couldn't have been worse than what happened. So, I think
you wrote that initiative, Mark. Aaron came up with the idea, and you wrote the initiative. The former city attorney, Tom Carr, told me he did not think that initiative could be enforced. He thought the city of Seattle could still accept a buyout if they wanted to, even if the initiative passed. What's your take on what Tom Carr shared with me?
Well, yeah, the former city attorney,
Correct,
Tom Carr, had I think I think he and I have a different view of sort of the citizens' role in the legislative initiative process, and I think that there are certain areas that citizens aren't allowed to impede into. But I think when you draft an initiative that is narrow and it is sort of single focused in purpose, and it isn't getting into the bureaucracy of the city of sort of how they run the day-to-day operations, but rather is narrowly focused on a single issue of public policy, which I would argue, I mean, clearly the Sonics were something that was of great public interest to a lot of people. I would respectfully disagree with them. I think that's precisely the area of citizen legislating that both the city of Seattle and more broadly speaking, the state of Washington contemplate.
Interesting take. And Mark is an election law attorney. Aaron, pine in here. Tell us about I-93. You came up with the idea. Do you think it could have been something that could have changed the result of the whole relocation battle if that initiative passed?
That's a really good question, Paul. Looking back when we were involved in the Save Our Sonics effort, we were looking for any type of avenue in which we can slow down the process, if you will. Clay Bennett and his co-owners really wanted to get the team out of here, and any type of additional litigation could have easily delayed everything, delayed the move. And ultimately, looking back, as an armchair quarterback, if the city hadn't settled and they were forced to stay here, they probably would. The Sonics would still probably be here in Seattle. I think that initiative was an opportunity for the citizens of Seattle to mandate to the city that they didn't want to take a settlement. And we didn't. The elected officials of Seattle were not on our side in keeping the Sonics in Seattle.
You both gave really good answers. Now, one little piece of history from that whole I-93 initiative, which I think you guys in the Save Our Sonics people can wear with a little badge of honor, is apparently Clay Bennett wrote an email learning about I-93 where he wrote, Stern needs to get us out of Dodge.
Wow, that's inspiring fear in Clay Bennett.
Yeah, so I think the Oklahoma owners had some concerns about that initiative that you two worked on. Paul Schneiderman, host of Sports and Stuff on RainierAvenueRadio.world, having a great discussion about sports-related issues and sports law with Mark Lamb, a Bothell attorney, and Aaron Wolff, a Seattle attorney. Okay, I'm going to bring up something that is a great topic to start an argument at a Thanksgiving dinner. Colin Kaepernick is somebody where everybody has an opinion on Colin Kaepernick with his decision to kneel. It's really split the country in many ways. And like I said, it's a great way to start an argument at a family holiday dinner. Kaepernick, as we know, reached a confidential settlement in early 2019 with the NFL and concerned to his collusion claim. He's back in the news with his unprecedented league-hosted workout for an individual player. Now, I got a question for you guys. We don't know the terms of the confidential settlement that he worked out with the NFL. But one thing that's confusing me, and I want you two guys to pine in here, if there's already a settlement that Kaepernick had with the NFL, why does it seem like there's so much re-litigation now over his tryout and the waiver? Were these issues maybe not resolved earlier? Mark, you go first, and Aaron, why don't you pine in here? I'm just a little confused why there's so much almost re-litigation of a case that settled, apparently.
Yeah, I mean, I think it probably deals with the terms of what was settled. I mean, I think that would deal with his release, from the NFL, or his inability to continue playing in the NFL at the time, and sort of how Colin Kaepernick felt like he was treated. I mean, my sense of that is that there may be terms that are within the confidential settlement that we're not privy to that were guiding why the NFL took the position that it did. I mean, I don't know that because obviously it's confidential. I do think, the sense that I get with that, just globally speaking, is that there are times, and I know you guys have probably experienced this as attorneys, where the parties aren't in alignment and they're not ready to settle. And so sometimes an issue, in this case, like a waiver to, a liability waiver to work out in a facility or work out for teams, becomes the excuse to sort of, because you're not in substantive agreement, and there may be bad blood. I mean, clearly
is some tension.
Some significant bad blood. And so, I don't know. I listened to Stephen A. Smith when he was like, I think Kaepernick doesn't want to play and that's why he's doing it. I don't necessarily accept that narrative, but I think there is much more going on behind the scenes. I don't necessarily believe that what's going on under the surface, I think, is much more revealing of what the actual situation is. I don't think that the dispute was literally like they couldn't come to terms on a waiver, and that's why Colin Kaepernick's not playing in the NFL.
Jump in here, Aaron. Give us some perspectives that you have in this whole recent Colin Kaepernick flare-up.
Well, it's obviously a really complicated issue, and it's very divisive, Kaepernick. And everything that's been surrounding it. As Mark alluded to, the excuse, the scapegoat as to why it went from the Atlanta training facility to a high school outside of Atlanta was because of issues regarding liability waivers and things like that. But there's obviously multiple layers behind that, and neither Mark or I are privy to what those layers are. But I think when they initiated this and Goodell discussed or announced that this was going to happen, it appeared as if it was a PR stunt to show that the NFL has no ill will towards Colin. But a story also accounted that the Kaepernick team only had 2 hours to agree to the terms. And
I didn't know that. Interesting.
I read that just today. So it's truly a complicated issue. I do believe there were a few teams that were present for that modified tryout, if you will. And Kaepernick did give a statement that he's been trying to play for the past 3 years.
One more thing I want to throw in here on this issue is I've worked on a few employment law cases over the years. Not a ton, but I've had a few of them. Many employment law cases involve severance agreements where it's basically the aggrieved employee is told by the employer, here's some money. We don't ever want to see you again. You're not going to be employed anymore, but here's $800,000, $2 million, whatever. I assume that Colin Kaepernick in the NFL did not have any kind of severance agreement. I'll go ahead and pine in there, you guys. We haven't seen the agreement.
I would actually assume the opposite. I think they would have had some, but I mean, you're right. In a lot of severance agreements, I remember one case in particular where that was a real sticking point for the employer was like, you can never come back and work at this location again because sometimes you might have an intra fight or something like that where one party doesn't want the other party reemerging if they're displaced. In this case, I tend to think that it is, in a way right now, Colin Kaepernick's story is he wanted to play in the NFL. He was punished for his belief. To be honest with you, not to be mercenary about it, but there's a certain value to him in that story of, from Nike and from other things like that, of where his actions on principle led him to sacrifice a career in the NFL. That's sort of his narrative. I think if he tries out for a team and is unsuccessful or tries out for a team and is sort of relegated to a second or third string role, I don't think that really supports that narrative. And I don't know that most teams, given salary cap and other issues like that, would be willing to put the kind of money out there for someone who hasn't played in 3 years to make it worth his while to test that. And that actually is, I think, a distinct possibility in the Kaepernick case. I
may have not articulated my earlier point very well, my point a minute ago. I was trying to articulate that if he is trying out for teams right now, or if teams are even looking at him, there must not be a traditional severance separation agreement.
I don't think there was a provision that said he couldn't return to the NFL.
Gotcha.
And I think he probably would have balked at that at the time had it been
part
asserted,
of the confidential settlement. Aaron, anything else to add on the Kaepernick thing?
Well, I would agree. There clearly was no settlement as far as precluding or prohibiting Colin from future play in the NFL. Unfortunately, it's such a divisive issue, and so many people have so many different opinions, and it is really one to be discussed and conflicting points by every party. It'll be interesting to see how this plays out because there have been some NFL teams that have lost some of their star quarterbacks. There have been rumors that certain teams are interested. Whether or not it'll ever be in the league, only time will tell.
And that perspective comes from a prominent Seahawks season ticket holder, Aaron Wolff, too. So
I am a diehard Seahawks fan, absolutely.
Paul Schneiderman again on Sports and Stuff on RainierAvenueRadio.world, talking some sports law with two very good attorneys, Mark Lamb and Aaron Wolff. Okay, I want to move to another NFL topic, the Myles Garrett melee, the fight that occurred between the Cleveland Browns and the Pittsburgh Steelers a couple weeks ago. And my first question is for Aaron. I want Mark to jump in here as well. What do you think, Aaron, in general, about the idea of police and prosecutors getting involved in on the field pro sports violence? There are cases. There are some NHL cases.
NHL, exactly.
And there was a case of a Jose Offerman, I guess a minor league pitcher who threw a bat at a pitcher or something. But anyway, what's your general take on law enforcement getting involved in pro sports fights?
That's a really good question, Paul. That's tough. It's tough for law enforcement to get involved. I read some articles here, and by definition, what Myles did there is an assault. And it's not a reasonable inference or incidental contact when he took the helmet off of the quarterback, Rudolph, and then smashed him in the head with it. That, by definition, that's an assault. But they've already said the Cleveland police are not investigating, nor is the prosecutor's office planning on prosecuting. Obviously, the league has suspended him indefinitely, clearly through the end of the year. It's tough because when you watch that, it is, by layman's terms, just looking at it, seems very egregious. There have been comments, there might have been some slurs that were made. It's unclear here, but it is really difficult for law enforcement or police or any type of criminal prosecution to occur. It's happened before. I just don't envision it happening in this situation for this incident. And what will be interesting is to see how this all plays out, because Cleveland is going to be playing in Pittsburgh this Sunday.
That's right.
Yeah.
That's right. Well, it's very fascinating to hear a career criminal defense lawyer perspective on that. Mark, jump in here a little bit on this whole Myles Garrett, Mason Rudolph episode.
That game is definitely going to be some must-see TV when it comes back.
For sure.
I think it's going to be intense. No, I mean, I think the challenge is that they're probably – I always try and think about it in a situation like that. Like, I think what was observed, that the police and the prosecutor are making the right decision. I think if you interfere in a case like that, there are many times on almost every NFL game where somebody will shove somebody else or push someone else in the face. That would clearly be an assault, as Aaron pointed out correctly, outside of the context of the game. I think what's interesting to me is to think about, like, what if the situation had been different? I mean, what if he had seriously injured him? What if he was not able to continue playing? What would be the legal implications then? Probably both civil and potentially criminal, because he, in a way, both of them were lucky in that when you take a football helmet and you smack somebody in the head, as strong as he is and as hard as he hit him, it could have been much, much worse. And I think it's kind of a warning. I think what the NFL did was sort of say, hey, we're going to call timeout. We're going to remove him from the league for the rest of the season and kind of take a deep breath. But as a league and as a country that loves NFL football, I think we really lucked out that did not end up in a much more serious situation.
Could have been a lot worse, but there is a perspective, which I think on the video there has merit to it. There's a perspective that Myles Garrett's getting a little bit of a raw deal, that Rudolph apparently made contact with him first. Based on what I watched in the video, there were 3 players, including Rudolph, that were on Garrett when he was alone on the field at one time with 3 opposing players. Is Myles Garrett, Mark, and then I want Aaron to jump in here, getting a little bit of a raw deal?
So I think it's clear, as with most altercations in life and in the law, that there was blame to go around, that it was not this was not an unprovoked attack. He didn't take off his, the helmet while he was walking off the sideline and cold cock him. This was people who were engaged in a confrontation. Did he escalate that confrontation to a level that was inappropriate and unacceptable? I think so. But yeah, I wouldn't say that Garrett was the lone aggressor or the only person who had fault in that altercation. What's
your take? An indefinite ban on Garrett? Does that go too far? What's your take?
I think an indefinite ban goes too far. Excuse me. I do think through the end of the season is appropriate. There are no clean hands here, but what he did when he removed the helmet and then struck him with it, I would say, is the most egregious act, and ultimately through the rest of the season, I think is a warranted suspension.
You don't see what Garrett did. I'm playing a little devil's advocate here. You don't see it as like kind of a quasi self-defense situation at all?
Well, reasonable use of force. Was it necessary to take the helmet off him and then attempt to strike him in the head? I don't think so. When you had other players involved, I don't think he was fearing for his safety at that time. I think anger and the passion is what overtook him at that time.
Great perspectives. You guys have knocked out of the park. Paul Schneider going to host of Sports and Stuff on RainierAvenueRadio.world with my engineer today, James Gerd, and attorneys Aaron Wolff and Mark Lamb. We got about, 10 minutes, James? Yeah, about 10 minutes. Okay, a little less than 10. Okay, so I want to kind of move on this a little more quickly. A couple more subjects I want to get into more. But the Supreme Court in May of 2018, U.S. Supreme Court made a 7-2 decision where they struck down the Professional and Amateur Sports Protection Act. They ruled it was unconstitutional, part of a New Jersey challenge. Essentially, states have more discretion to regulate and legalize sports betting. And interestingly, marijuana issues have a federal state confrontation at times. Mark, what do you think of the ruling really quickly? And I want to get Aaron's take on this major sports gambling ruling the Supreme Court made last year.
Yeah, so I'm a big believer in states having the right to determine matters that are closest to them. I think the decisions in government that are made closest to the people tend to be the decisions that are right. I think there are states that will opt to go all in, to use a betting term, on sports gambling, and I think there are others that will likely take a pass. But I think that the implications of that, I've heard a lot of the arguments against the ruling, to me, seemed less substantive and more sort of policy oriented, that they were saying, well, this is going to lead to a proliferation of sports gambling. The reality is, like, Americans love to bet on sports. Sports gambling is a huge industry. It's something that many, many people choose to participate in this country. It's a voluntary activity. Nobody's forced or compelled to engage in sports betting. And I think having states have the ability to say, yeah, that's something we'd like to have as part of our community, or not, is something that ultimately is for the legislature and for the elected representatives and for ultimately the people of each state to decide, not to have one size fits all in our country.
Sounds like an opinion written by Chief Justice Lamb.
Thank you.
Aaron, what's your take on that Supreme Court decision where the states aren't given more discretion to participate in sports gambling?
Well, sports gambling is a multi-billion-dollar-a-year industry. And I echo Mark in the sense that states should have the right to decide whether or not to legalize it and ultimately to tax it. Currently, if a person wants to lay a bet and they do it illegally, usually it's through a bookie, and their bookie always makes a profit in this case. Why not afford the states the opportunity to make profit, just like in the context of lotteries that many states have? As a person who does on occasion enjoy sports wagering, legalized that is.
That's right.
Yeah, of course.
In a state called Nevada, well, that right.
Absolutely,
Okay.
Paul.
Right.
That ultimately it is one activity that millions of Americans enjoy doing. So I think it's absolutely the right decision here and an opportunity for more income for the states that do decide to legalize it.
And I would echo what Aaron just said. I've litigated against the state of Washington many times, and at times they have, in fact, acted like an extremely aggressive bookie.
That is an interesting analogy. Paul Schneider again on Sports and Stuff with on Rainier Avenue Radio with Mark, Lamb and Aaron Wolff. Well, I wish we had more time because I've got a couple minutes left. I want to hit a few more subjects. Okay, there was a major NCAA case that came down this year, Alston versus NCAA, in the courtroom of U.S. District Judge Claudia Wilkin. This is the Ninth Circuit. It was an interesting decision. The plaintiffs prevail, but the NCAA is still able to retain a substantial amount of discretion over student-athlete compensation. In some, the NCAA is no longer allowed to limit education-related benefits for student-athletes, but the NCAA still has a lot of discretion, and they also can define the term related education. I know that's a mouthful, like a lot of legal decisions are. Antitrust case, I guess the biggest thing I got out of this case, and I want to know if you guys agree, is that schools, the NCAA can no longer cap the educational parts of scholarships. And is this ruling a sign of something bigger to come down the road? Could there eventually be just complete college pay? Go ahead. I know I'm asking a couple questions within a question, Mark and Aaron, but go ahead and just give me your thoughts, whether this is just a sign of some bigger rulings to come, maybe.
I think it's a fundamental foundation of our country and of sort of labor and economics that people should not have either their likeness or their labor taken without compensation. And I think that it's without question that there are many athletic programs, college athletic programs, that have made an enormous amount of money by using the likeness and by using the labor of student athletes, and have kind of, I would say, chosen to prosecute individual, in air quotes, violations of their policies in a way that really hasn't been fair, and has oftentimes, I think, targeted communities of color and lower income people in a way that isn't right. I think student athletes who are generating revenue for their school should have the opportunity to participate in that revenue. I also think that other athletes in sports that aren't necessarily as revenue producing, like golf or tennis, those students by this ruling would have the opportunity to teach lessons and to have an opportunity to get income outside of that. College athletics is a really special place, but I think that we can make room in this country for some kind of a compensation. And I think, frankly, a lot of schools already engage in that, and a lot of boosters already engage in that, and this would be an opportunity to cast some sunshine on that practice.
Aaron, what do you think of this legal decision in some where the NCAA is no longer allowed to limit education-related benefits for student athletes?
I totally agree with it. In the context, just as Mark said, student sports, student athletics is huge profits for each university, and an individual who is playing at a collegiate level clearly has a gift or a talent that ultimately they should be afforded the opportunity not to be able to have a unlimited education, if you will, and the opportunity to derive some form of income from the benefit they're providing the university through their exemplary play.
Go ahead, Mark.
I was going to say also, I think this may have the potential down the road of ending the phenomenon of one and done if people have an opportunity to keep more of what they participate in making, and that where people just play for a year and then go to the NBA or NFL.
Well, on a personal note, on a pure policy level, I like it now that the NCAA doesn't quite have the latitude they used to have on some of these questions, and I think it's good that when you're limiting educational benefits to athletes, that creates all sorts of other problems. Another issue going on, which is related to this NCAA case that was decided by a U.S. District Judge in California, I'm sure the Ninth Circuit's going to take it up soon, is that the whole college pay issue. And there is a state representative in Washington State, Drew Stokesbury, who is sponsoring a bill allowing college athletes to be compensated for anything up to fair market value of services and retain an agent. Mark, you know state politics real well. What do you think of legislation? You think it can pass? And Aaron, I'm going to get your opinion on it as well.
I think it's a good move. I know Drew very well. I like him. He used to be a paralegal for me at my law firm. He's a fantastic guy, and I think he's right on this issue. I think that people, again, it goes to the idea of a fair use. There's some colleges who aren't generating revenue from it, and that's okay. I mean, they're not going to be implicated by this. But I think that people who have who are risking their safety and who are putting their talents for the benefits of an institution have a right to be compensated for it.
It's kind of an issue. You can get people on the left and right kind of uniting on that. It's interesting. Like a minute left here, and I want to get your take on this bill that is being sponsored in the Washington State Legislature to allow college athletes to be paid.
I agree with it. Absolutely. Unequivocally.
One thing that will be complicated if there is college pay for student athletes is the whole Title IX issues and all that. It could get pretty complicated. Would you guys agree with that?
Yeah, potentially. I thought you were going to say the whole IRS issue of having to pay taxes on the income, but yeah, that would be a complication.
What do you think, Aaron? Could the Title IX issues, rowers can be paid the same as star football players? How are we going to handle all that? Or how would the NCAA handle all that?
That would be a very, very difficult decision, and there were multi-layers of conversation as to what each player and their sport they're entitled to. You would think that they should be entitled equally, but obviously different sports generate different forms of income.
You guys were absolutely excellent today. Thank you so much for coming on Sports and Stuff on RainierAvenueRadio.world. Mark Lamb and Aaron Wolff. What a great discussion. I hope to have you guys back one day. We can hit on this some of these subjects again in the near future. But I really appreciate you guys coming on.
Thanks so much for having us, Paul.
Yes, thanks, Paul, and happy Thanksgiving.
You too. Happy Thanksgiving, everybody. Thanks, guys.